Welcome to the deep dive. Today, we're tackling, well, a really fundamental idea in criminal law, that the law generally punishes what you do, your actions, not just your thoughts or plans.
Right. You can think about it, plan it all out.
Meticulously even. Gather tools, know the steps.
Exactly. But until you actually do something, take that step beyond just prepping. Well, criminal law usually isn't involved.
That distinction is just so critical, isn't it?
Absolutely. It's not about policing thoughts. It's about the conduct, the physical thing.
And that takes us straight to the absolute core concept, the actus reus, the guilty act.
Or the objective bit of the crime.
Yeah, so today we're doing a deep dive into two really vital parts of that actus reus, the conduct element and the circumstances element.
And getting these clear as well, you just have to. It's foundational for understanding criminal liability. If you can't pin down the right conduct or circumstance for a crime,
Then you can't establish the actus reus.
and no actus reus, no crime. Simple as that, really.
So our mission today is to really unpack these ideas. We're drawing on some excellent source material made available by the University of London for educational purposes.
And we really appreciate the University of London making these resources accessible. It's fantastic for students.
It really is. We hope this deep dive helps you navigate them. Oh, and this is brought to you by Sinorbit Academy, Sri Lanka.
And for everyone studying this, especially, with exams maybe coming up.
Yes, the very best of luck from both of us. We hope this helps cement these key ideas.
Good luck. Right then, let's get into the structure of the actus reus as the material sets it out.
Okay, so the source explains actus reus can have three parts. Conduct, that's always needed. Then circumstances, which are sometimes required.
And result, also sometimes needed. It depends on the specific crime. But yeah, today, conduct and circumstances, that's our focus.
And central to conduct is the act requirement. Basically, liability usually needs a wrongful act.
The default position is no act, no liability, generally speaking.
So what counts as an act for the law? The material gives us two key ingredients. First, it has to be a bodily movement.
A physical movement, muscles doing something. Like if you think about murder,
Yeah.
the conduct, the act, is whatever bodily movement caused the death. Poisoning a drink, that's a movement. Cutting brake cables?
Also movement. And the case of Hayward from 1908 is mentioned, which is interesting.
Yes, because there wasn't direct physical injury caused by touch, was there?
No. He threatened and chased his wife. She had a heart condition, and she died from a heart attack caused by the fright and exertion.
And the court said that threatening and chasing, that was enough. That was the bodily movement, the act that caused her death.
So the flip side of needing a bodily movement is crucial.
Which is that doing nothing, just, not lifting a finger, generally isn't an act in criminal law.
Even when it feels really wrong morally. Like illustration 3.1. Noor sees Parveen, who's blind, about to walk into the path of a lorry.
And Noor dislikes Parveen and just watches, does nothing. Parveen is killed.
Morally shocking. But legally,
Legally, based just on that failure to act, Noor hasn't committed the actus reus of murder or manslaughter. No bodily movement from Noor caused the death. The omission, the failure to help, isn't an act.
okay, so bodily movement is one part. What's the second requirement for an act?
It has to be voluntary. The bodily movement needs to be under the control of the mind.
And for this, we look to Braddy v. AG for Northern Ireland, don't we? Lord Denning's definition.
Exactly. He explained an involuntary act is done by the muscles without any control by the mind. Things like spasms, reflex actions.
Convulsions or things done while unconscious. Like concussion, sleepwalking.
Precisely. Illustration 3.2 gives a good picture. Aisha trips over a brick, stumbles completely uncontrollably into Yasmin.
Pushing Yasmin into the road where she gets hit by a car.
Aisha's stumble, the movement that pushed Yasmin, wasn't voluntary. It wasn't consciously controlled. So no criminal liability for Aisha for the injury caused by that stumble.
And this legal state of acting involuntarily, that's called automatism.
Automatism. It negates the voluntary element of the actus reus, so it can be a defense. It's a whole topic in itself. But the key point for us now is involuntary movement, not a legal act.
So identifying the required act depends on the crime's definition. Sometimes simple,
Those
sometimes...
it's trickier. Yeah, you have to look closely.
Okay, so baseline. Liability usually needs a voluntary act. But criminal law loves exceptions, right?
Always. And there definitely are situations where you can be liable without a positive act. The material points to three main types.
First up,
Statutory crimes of omission. These are specific laws that say you must do X and the crime is failing to do X.
like not wearing a seatbelt. Or not taxing your car.
Exactly. Failing to file a tax return, not displaying a license plate, often regulatory thing.
And sometimes strict liability, meaning your intention doesn't matter so much.
Often, yes. The focus is just on whether you complied with the duty the statute imposes. Did you do the thing or not?
Okay, second category of exception.
Crimes of possession. Liability here comes from just having something illegal.
Controlled drugs, offensive weapons, certain images.
Right. And the material notes a point here that can be, well, controversial. Liability can arise even if you didn't choose to possess it or didn't know exactly what it was.
Like the Diemi case from 2008.
Yes, the taser disguised as a torch. He claimed he thought it was just a torch.
But that didn't matter.
Didn't matter for liability for possessing a prohibited weapon. The fact was, he possessed the prohibited item. His belief or lack of intent wasn't the key issue for that specific offense.
Wow. Okay, so that's moving away from acts towards punishing a state of affairs being in possession.
Sort of, yeah. Which leads into the third exception, situational crimes.
Where the actus reus is just being somewhere or in some state you shouldn't be.
Exactly. Drunk in public, drunk in charge of a vehicle, owning a specific breed of dangerous dog.
Or allowing any dog to be dangerously out of control in public.
Mm-hmm. And again, the material stresses liability here doesn't necessarily need an act or even fault. Remember Elvin from 1994, the dog control case?
The defendant took reasonable steps, but the dog was still dangerously out of control.
Right. And the crime was complete just because that prohibited situation existed, which is why some commentators find cases like Windsor
Being found drunk on the highway after the police put him there.
yeah, and Larcener being unlawfully in the UK after being forcibly returned by Irish police find them objectionable. It seems like punishing someone for a situation they didn't voluntarily create.
Okay, so we have the general rule. Need an act. Then exceptions. Statutory omissions, possession, situations. Now for the really tricky bit.
Ah, yes. Crimes of commission by omission.
Can crimes usually defined by an act, causing a result like murder, unlawful killing, can they actually be done by not acting, by an omission?
This is where it gets legally complex and, frankly, debated. Killing makes you think of doing something stabbing, shooting.
An act.
But causing death, that could happen through inaction, couldn't it? A parent not feeding a child? A caregiver withholding medicine?
So the big challenge is line drawing, right? If failing to act can be a crime, who's liable? Everyone who could have helped.
That's the policy concern. Think of Sir James Fitzjames Stephen's famous example. Seeing someone drowning, you could easily reach out a hand, but you don't.
Morally awful.
Definitely. But legally, is it murder or manslaughter? Generally, no. Unless you have a specific, legally recognized duty to act.
This makes the distinction between an act and an omission incredibly important here.
Absolutely fundamental. That scenario, holding out a hand, they grab it, then you deliberately let go. Is letting go an act causing death? Or an omission failing to keep holding on?
And the answer could mean the difference between potential murder liability and none at all if there's no duty.
Precisely. You have to go back. Was there a positive bodily movement causing the harm? Releasing a grip could be seen as an act? It's debatable.
So to stop the floodgates opening, the law has these strict requirements before you can be liable for a crime like murder or assault by omission. The material lays out 5 key points. These are crucial.
5 hurdles the prosecution must clear. Let's go through them. Number 1.
1. The crime itself must be capable of being committed by omission.
Right. Most result crimes, murder, manslaughter, criminal damage, even theft in some contexts they can be, but some crimes just inherently require an act.
Like assault?
Assault is the classic example. It needs an act. The case R.V. Dunn from 2015 is mentioned. The defendant got the victim to perform an indecent act.
But the defendant didn't do the act themselves.
Exactly. And the court said indecent assault requires the defendant's act. Causing someone else to do it wasn't enough for that specific charge. The crime wasn't capable of commission that way or by omission.
Okay, requirement 2. This feels like the big one.
2. The circumstances must create a legal duty to act, not just a moral one, a duty the law recognizes.
Parents have statutory duties to kids. What else?
Duties can come from contracts, certain relationship spouses, sometimes partners or family members if responsibility has been assumed.
Like taking care of an infirm relative.
Potentially, yes. Also, if you've created a dangerous situation yourself, or from an official position like a police officer, but crucially, no general duty to rescue strangers, Stephen's drowning person again generally, no legal duty to save them.
The material mentions scenarios like pool attendants, family ties. but stresses things like adult siblings or partners aren't automatic duties unless specific responsibility is taken.
Correct. It's about legally recognized duties, which are quite limited.
Third requirement.
3, the defendant's failure must breach that duty. So even if you have a duty, maybe you did all you could, or it was impossible to act, or the failure was justified somehow, it has to be a culpable failure.
Okay, fourth.
4, the failure to act the omission must be voluntary. Same as for acts. If you failed to act because you were unconscious or tied up.
Then the omission wasn't voluntary. No liability.
Right. And finally, number 5.
5. The harm must have been caused by the omission.
And this is often the toughest part for the prosecution. They need to prove, beyond reasonable doubt, that the harm happened because the defendant failed to act, that the omission was a necessary cause.
The case for this is R.V. Morby from 1882. The parent who didn't get a doctor for a sick child,
That's the one. Child died of smallpox. Parent convicted of manslaughter initially.
but overturned. Why?
Because the prosecution couldn't prove the child definitely would have lived if the doctor had been called. They couldn't establish causation. Would medical intervention have saved the child? Maybe, maybe not. The prosecution has to show the harm wouldn't have occurred but for the omission.
That's a high bar. So those 5, again, quickly. Crime capable by omission, legal duty exists, breach of duty, voluntary omission, and causation.
Master those 5, and you've got the core of liability for omissions. Very important.
But let's quickly loop back to some cases. Hayward, an act causing death, even indirectly.
Brady defines involuntary acts, basis for automatism.
Elvin, Diami show liability in exceptions, situational or possession, even without full knowledge or fault about the circumstance or item.
R.V. Dunn confirms assault needs an act can't be done by omission.
And Airedale, NHS Trust v. Bland, the life support case, really highlights that act versus omission distinction.
Crucial there. Calling withdrawal of treatment an omission meant doctors weren't actively killing, and since there's no duty to provide futile treatment, it was lawful. If it had been classed as an act, it might have been murder.
Shows how legally critical that distinction can be. And Morby shows the causation problem for omissions.
Definitely. One other interesting one is Fagan v. MPC, the car on the policeman's foot.
All right, the initial act was accidental, involuntary.
But then he was told to move, knew he was on the foot, and deliberately didn't. The court treated that failure to move, that omission, as part of a continuing act of assault that started when the car first landed on the foot.
Ah, so they sort of bypassed the pure omission rules there.
Kind of. It's seen as a way the courts sometimes link an initial act with a later failure to remedy it. It also links to the Miller principle.
Creating a dangerous situation, like starting a fire accidentally.
Yes, or Evans supplying drugs. If you create the danger, you then gain a duty to take reasonable steps to fix it or avert harm. Failing to do that can then be the omission that leads to liability.
Okay, great. Let's shift back slightly to the other element we planned for today, circumstances.
Right. The context. Some conduct is only criminal because of the circumstances surrounding it.
The easiest example is consent, isn't it?
Sure.
Sex, or just touching someone.
Perfectly fine with consent, but do the same thing without consent.
That without consent is the crucial circumstance that makes it the actus reus of rape or assault.
Exactly. Or look at theft. The conduct is appropriating property.
But it's only theft if the circumstances. The property belongs to another. You can't steal your own stuff.
And the Firearms Act example. Conduct. Possessing a firearm. Circumstance. Without a certificate or other legal authority. With the certificate, the possession is fine.
So conduct is the action or omission. Circumstances are the surrounding facts the law says must also be present.
Got it in one. They provide the necessary context for the conduct to be criminal.
Okay, so wrapping up our main discussion. It's worth just restating that holding people criminally liable for not acting, for omissions, especially for serious crimes, it is still pretty controversial, legally and morally.
Oh, definitely. There's a constant debate. Should we expand the situations where a legal duty arises? Should we have a general duty of easy rescue?
You mean if you could easily save someone without risk to yourself, you have to?
That's the proposal some argue for. Arguments for it are often based on morality, social solidarity, preventing harm.
And the arguments against?
Often focus on individual liberty. The idea that criminal law punishes bad actions, it shouldn't force people to be heroes or intervene. Where do you draw the line on easy? What level of risk is acceptable? It's a real balancing act.
A tension between, punishing blameworthy inaction and protecting individual freedom not to act. So let's summarize the key takeaways from this deep dive. We've looked at the actus reus, we've dug into conduct, which usually means a voluntary bodily movement, the act requirement.
We covered the exceptions. Statutory duties to act, crimes of possession, and situational crimes where just being is enough.
And we really unpacked the complex area of crimes, of commission by omission, those 5 strict requirements: capability, legal duty, breach, voluntariness, and crucially, causation. Remember, more beyond causation.
And we highlighted the role of circumstances the context needed, like without consent or property belonging to another.
Understanding all these distinctions, act versus omission, duties versus no duty, the role of circumstances, it's just fundamental for studying criminal law.
Absolutely essential skills.
And maybe a final thought for you to mull over as you study. Does the current law, particularly with its limits on omission liability and no general duty of rescue, strike the right balance between individual liberty and perhaps a social responsibility to help others in peril?
It's a question that keeps lawyers and ethicists busy, that's for sure. No easy answer there.
Indeed. Well, once again, a huge thank you to the University of London for making the source material available for education purposes.
It's invaluable.
Here, here. And this deep dive was brought to you by Sinorbit Academy, Sri Lanka. To all you students tackling this, especially if exams are looming,
We really wish you the very best of luck.
keep working through it.
You absolutely can do this. Good luck.